So the common law through the English perspective, what do we know about the common law as a source of law in the Commonwealth Caribbean? What do we know?
All right, so sir, before the Norman conquest,
Mm-hmm.
England did not possess a unified legal system. Different areas use different areas of law. Different areas in the country use different areas of law, and it varied from place to place because of the different invaders. So when William the Conqueror came to throne in 1066, he began to standardize the law and decreed that all law in the country would be common law.
Well, he decreed that there would be one law common throughout all states in the country, right? And that is why it's called the common law. If you get what I'm saying, it's one common law among all of them, therefore it's just called the common law, right?
Yes, sir.
So lovely, 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 lovely start to that. What a beautiful response. All right, so let's look at the common law, right? So before the Norman conquest, pre 1066, we know that we have Anglo-Saxon legal traditions existing within England at the time, right? So you have customary laws. So each different village or if each different section, for example, Northumbria, Wessex, Mercia, all these different areas, these different kingdoms within England, within the British Isles at this time, right? Practice their own local customs and traditions into law, right? The king's law, right? So the king issued laws known as dooms or decrees, which were complied, right? Sorry, compiled into collections, right? So notable collections included those of King Alfred and all these different things, different Mosaic laws, Christian principles, traditional customs. So these things are passed on to the different kingdoms, right? Within England itself. They also had local courts that worked by different ways and through different institutions. So all the laws varied, right? Okay? So at all of these issues, the legal procedures were also different, right? So looking at these different things, it was all somewhat mixed up. Right after the Norman conquest, right, so post 1066, the Norman conquest in 1066 marked a significant turning point in the development of English law. William the Conqueror and his successors introduced new legal concepts and practices that laid out the groundwork for the common law system. So look at the centralization of the king's justice. So royal courts were made. So the Normans established a centralized system of justice, diminishing the influence of local courts, and the king's justice became the paramount court. So the king's court specifically, right, the Curia Regis was the fountain from which all justice flows, right? We're gonna have inherent justice, right? So to ensure uniform application of the law, right? Right? So if we look at the purpose that we're trying to do, we're trying to make sure that all the law is really uniform within the place, right? So we're looking at the different justices, right? Judges who traveled through the country and were appointed, right? They had assizes or sessions, right? In various localities, bringing royal justice to the people. So these were basically the first time in which throughout generally across an entire country, right, we had, well, not the first time, but the first time in England, right, specifically, we had this centralization of law, right? We had things like the Doomsday Book being commissioned, right, in 1860, in 10 um 86, by the way, right? So it was basically an extensive survey of land holdings and resources in England, and it served not only to record for taxation purposes, but also a tool for resolving disputes over land ownership. So they try to now centralize everything, keep records of everything, and keep it all within the king's justice, right? Of the development of a common law principles as well, case law and precedents started to build up. Over time, decisions made by the royal judges in individual cases began to be recorded and referenced in subsequent cases. This practice led to the development of the body of case law, forming the basis of the common law system, where precedents, which is past decisions, guided future rulings. And you guys can see the advent of stare decisis there. The writ system was also important. So the Normans introduced the writ system, a formal written order issued by the king or his officials. So writs such as writs of habeas corpus and writs of trespass, right? Standardized legal procedures and provided mechanisms for individuals to bring cases before the royal courts. So this was the first really part or the time before we had what is that term again? I think the term slipped me. It starts with an L, right? But it's a first form, right, of determining whether or not a person has a right to come towards a court, right? We also have the Magna Carta in 1215, right? So through those slightly later, right, that document itself was the development of the common law. So the Magna Carta was the true crucial development, right, of common law in codification. It was established, right? It established the principle of the that the king was subject, right, to the law, right? So it was that was the integral part there, right? So the Magna Carta was the first um document which stated a rule of law, right? So rule of law is a completely truly ancient thing. So it established principle that the king was subject to the law as well and laid the foundation for certain legal rights, including due process, protection from arbitrary imprisonment, etc. Right? So we have the development of the British common law there, right? And now we have the integration of the Norman and Saxon law. So we're looking at, the Normans were from France. So the integration of the Code Noir and the Code Civil from France, right, and the mixture of these old Germanic laws and Anglo-Saxon laws, right, in England. So they merged together to form what is called the centralized common law. So it developed into what we know today as the overall common law, right? And we're speaking about the Commonwealth Caribbean territories now and how the common law really came here. We're really looking at the plantation paradigm, right? And how we look at how law was given or this common law was transferred to English speaking Caribbean territories through this type of colonizer concept, this colonization concept, right? So of the colonial legacy, right, of British colonialism, French colonialism, Dutch colonialism within the Caribbean countries, right, which established a foundation that would persist to countries gaining independence, right? Or persist through countries even after gaining independence. So we still use the common law systems even though we're independent, right? We're somewhat independent. We have control and power as well, right? So we're looking at that there. The control extends to the legal realm where British laws and legal principles are imposed on the local populace, right? So the same British laws that are there within the common law practices are still imposed within the Caribbean, right? We have the impact on legal systems. So the English common law, right? This legal system in the Caribbean countries were heavily influenced by the English common law, right? This transplantation occurred through the establishment of colonial courts and the introduction of English legal principles and application of English statutes and case law. And when we talk about colonial courts, we're generally looking at these British colonial authorities that were set up within the Caribbean, right? We look especially on slave plantations, right? We're looking at the fact that local judges often trained in England, right, and apply those principles and rulings that they heard about, right, in England, and brought it back to the Caribbean to practice these legal traditions, right? So adoption of the common law, right, in the Caribbean. That's what we're really talking about. So judicial precedent, right, would be the next thing that we look at. Right? So that's really the development of common law, right? The British common law, right? The use of it, the utility of it, right? Within how it started the judicial precedent thing, right? How we look at the advent of the rule of law in the Magna Carta of 1215, right? We could look at all of those different things, right? Especially with how the common law came to the Caribbean, to the paradigm shift, right? Or to through the plantation paradigm rather. And it's important to know that different Caribbean territories would have different aspects of different law. For example, Roman Dutch law is prevalent within the Guyanese legal system, right? The Code Noir is present, right, within the French Caribbean, right, and the Code Civil as well, right, within some aspects of the French Caribbean, and the common law would be strongest within the British Caribbean, right? So we could look at all of those different things and the fact that the laws that the colonizers brought here, or the metropoles brought, would be completely instilled in these countries and societies until this day. All right, that should be fine. Any questions or concerns?